The formation of the long-awaited Labor Arbitration Tribunal was described as a red-letter day for the Virgin Islands by Deputy Premier Dr. Kedrick Pickering. The Labor Arbitration Tribunal is mandated by the 2010 Labor Code. Dr. Pickering said ensuring that the labor market functions properly and to international standards led to the establishment of the Labor Dispute Tribunal and the appointment of a veteran lawyer, Paul Dennis QC, as the first chairman.
Mr. Paul Dennis, QC, possesses the requisite experience and qualifications as delineated in Section 29(3) of the Labor Code 2010, which states, and I quote, "The chairperson shall be an attorney at law of at least 10 years standing and shall be appointed by the minister in consultation with cabinet for a period of 2 years," unquote.
Paul Dennis QC anticipates challenges but says the tribunal is ready to proceed. Noting that there are pending cases to be brought before the tribunal, Dennis explained that disputes will continue to be reviewed by the Labor Commissioner in the first instance. And when those issues are not resolved, they are seen by the Labor Minister, who can now recommend that the case be dealt with by the Labor Arbitration Tribunal.
Initial complaints or disputes will continue to be referred to the Labor Commissioner, who will have the first shot at resolving such disputes. If for whatever reason a resolution is not arrived at that level, then the Labor Commissioner refers the dispute to the Minister. And then among the options available to the Minister for resolving the dispute, if he's not able to do so himself, would be a referral of that dispute to the tribunal. So the tribunal will only deal with cases on the basis of referrals from the minister. And that needs to be kept in mind and to be clearly understood so that the public does not labor under the perception that the tribunal is there to hear initial complaints.
Based on recommendation of the parties involved, Dennis QC will sit with 2 other members on the tribunal. Already there are some cases to be seen by the tribunal that have gone through the process. Responding to a question from the media, the chairman says the tribunal is an adjudicative body with decisions that are legally binding. He also disclosed that person can appeal decisions by the tribunal, but only on a matter of law.
What that means is that once the tribunal has heard a case, its adjudication and decision on matters of fact are binding on the parties. No one and no court is allowed to look behind that. If, however, in coming to its decision, the tribunal applies the appropriate law applicable to that case incorrectly, which then results in an incorrect conclusion or decision, then an aggrieved party may appeal to the High Court on that point of law. And the High Court then has the jurisdiction to either affirm the decision or to overturn the decision if indeed it finds that an error has been committed.
Meanwhile, Dr. Pickering told the media that some 80% of labor dispute cases are handled by the officials within the Labor Department.